conflicts, diminution of ethical ideals, ill-turned economic conditions, economic deprivation, erosion of moral values, exploitative outcry of the oppressed. The crime index reflects the prevailing public order and tranquility, communal and religious feelings, juvenile delinquency, unemployment, addiction to alcohol and drugs. As we have discussed previously, crime and punishment are the two sides of the same coin. Crime attracts punishment. The purpose of punishment is not just retribution, but also deterrence and reformation. The sentencing policy has evolved over the passage of time, and now not only the nature of the crime, but also the circumstances and background of the criminal is considered while awarding punishment. Punishing the wrongdoer has been a primary function of all the civil societies. The incidence of crime and its retribution has always been an unending fascination for the human mind. However, during the last 200 years, the practice of punishment and public opinion concerning it have been profoundly modified due to the rapidly changing social values and sentiments of the people. The crucial problem today is whether a criminal is to be regarded by the society as a nuisance to be abated, or an enemy to be crushed, or a patient to be treated, or a refractory child to be disciplined. Or he should be regarded as none of these, but simply be punished to show to others that antisocial conduct does not find place. In this regard, the suggestions made by Sir Walter Moberly assumes importance. Sir Walter Moberly suggested that punishment presupposes the following. First, what is inflicted is an ill, that is something unpleasant. Secondly, it is a sequel to some act which is disapproved by the authority. Thirdly, there is some correspondence between the punishment and the act which has invoked it. Fourth, punishment is inflicted that it is imposed by someone's voluntary act. Fifth, punishment is inflicted upon the criminal or upon someone who is supposed to be answerable for him and for his wrongdoings. In this regard, the Supreme Court of India, in the case of State of Madhya Pradesh versus Hakam Singh and another, has reiterated undue leniency in awarding sentence needs to be avoided because it does not have the necessary effect of being deterrent for the accused and does not reassure the society that the offender has been properly dealt with. Now viewers, we shall be discussing the meaning of punishment. Punishment means to cause pain and sufferings on the wrongdoer for the wrong or sin committed by him or her. Punishment has been in vogue since time immemorial. However, in the recent few decades, it has been rationalized. Penology, which is a sister branch of criminology, deals with punishment, its objectives, kinds, and justification. The meaning of punishment can be understood from the philosophical, moral, legal, and ethical standards. From the moral justification, as quoted in the Holy Bible, "Thy have sown the wind, and thy shall reap the whirlwind." From the legal perspective, let the punishment fit the crime. From the criminological aspect, as pointed by Cesare Beccaria, justification of punishment must be to deter the potential criminals. In the ancient Hindu text Manusmriti, Punishment governs all mankind. Punishment alone preserves them from all sides. Punishment wakes when all are asleep. The wise therefore considers the punishment as the dharma or super dharma. Now viewers, we will try to answer the question as to why do we punish. Crime erupts and ignites the popular sentimental interest. Fear, desire for revenge, a certain morbid fascination, and a sentimental interest in the victim or even in the perpetrator of crime. Such emotions help explain the prominence given to crime in the press or on the screen. Before discussing the rationale behind the penal policy, it is imperative to focus upon what is crime. Hall Jerome, in his General Principles of Criminal Law, has defined crime to be an act or omission legally forbidden and intentional action which has a harmful impact on the social interests, which has a criminal intent, and which has legally prescribed punishment for it. According to him, in order that an act may be viewed as a crime, it must have the following characteristics. First, the behavior must be harmful in terms of its impact on the social interests. Secondly, the harm which is occurred by such act must be legally forbidden. Third, the act bringing harmful consequences must be intentional. Fourth, the act to affect the harm must have deliberate motive. Fifth, there must be a fusion of criminal intent and conduct. Sixth, the act should be sanctioned by the state as a felony. Persons can be punished only for those acts that they may be considered socially harmful and for which some punishment has been provided. Thus, the rationale and objective of punishment has evolved with the passage of time. When we turn back the pages of history, we see that in the most primitive times, punishment meant infliction of unbearable pain and suffering to the wrongdoer, like throwing before the wild beasts or putting the culprit in hot burning oil. It was felt that the wrongdoer was possessed with an evil spirit and harsh punishment was given to get rid of the evil spirit. With the passage of time, criminologists started thinking on the urgent need of rationalizing the punishment. It was felt that punishment should depend upon the nature of the wrong done, attributes of the wrongdoer like age, gender, mental understanding. Thus, the meaning of punishment also evolved and it became less arbitrary and more subjective. With the Universal Declaration of Human Rights 1948 and significant research in criminology and penology, the approach and meaning of punishment changed towards reformation and reintegration. Punishment started to mean pain and sufferings inflicted on the convict after giving him a fair trial and observance of due process of law to reform him and make him a better individual. Thus, the entire meaning of punishment has changed with the passage of time. Punishment, my dear viewers, serves diverse ends and is considered to be legally and morally justified as well. It is a multifaceted aspect of the ever-evolving criminal justice system. Now, when we look at punishment from the individual perspective, that is, the immediate and direct victim of the crime, for instance, the victim of rape or an acid attack. It gives assurance that the wrongdoer has also suffered pain, humiliation, and suffering by the state machinery. Now, from the societal perspective, it promotes social coherence and united abhorrence against crime and criminals. For instance, after the Nirbhaya gang rape case, people from all walks of life demanded death sentence for the rapists. Thirdly, from the perspective of the state, the government has the primary duty to protect the life of its people. Thus, by dispensing justice, the government machinery, through its different stakeholders, work towards punishing the guilty. Punishment can also be understood from a philosophical pursuit, and it is legally justified. However, the practical consequences of punishment differs from time to time and place to place. Now, a very important and crucial question: does the emotion of fear play an important role in man's life? In the primitive societies, the concept of state originated for the protection of people and their property. Private retribution gradually faded away, and the state became responsible for sentencing the wrongdoer. The concept of an eye for an eye and a tooth for a tooth became less popular. Even in the ancient times, punishment was important for the following reasons. Firstly, from preventing the wrongdoer who had committed the crime from repeating the offense. Secondly, to serve a warning signal to other people indulging in deviant behavior. And thirdly, morally justified that if a person causes harm or injury to another, he or she must also suffer the pain. It becomes important to understand punishment from the following perspectives. So, starting from sentencing as a facet of social justice. In heinous crimes like rapes, murders, sexual abuse of children, acid attacks and terrorism, a strict sentencing policy may reflect the popular social sentiment. Secondly, lawful vengeance. The basic object of a state is to protect the life and property of its people. Thus, the state is very much interested in awarding adequate punishment to the wrongdoer. However, in the criminal justice administration and in the quest for justice, the state cannot deny the accused a fair trial. Punishment also serves the ends of deterrence. Listeners, a crimeless society cannot be envisaged. Crime is bound to occur. However, the fear of punishment serves as a deterrence to future criminals, and it may also help in nipping the evil in the bud itself. Punishment also helps in balancing of conflicting interests. After every crime, particularly crimes against women and children, a lot of unrest, agitation and anxiety is witnessed among the people. The different stakeholders of the criminal justice system have to ensure that the conflicting interest of the victim on one hand and that of the accused to be presumed innocent till proven guilty are safeguarded. So the task of the penal policy is to strike a fair balance between these two conflicting interests. Now coming to another important facet of a progressive civilized society. Dear viewers, gone are the days of private vengeance and a tooth for a tooth and an eye for an eye. Nowadays, the victim of crime approaches the state for the redressal of his grievances instead of taking law in his own hands. Thus, the modern penal policy, with a convergence of deterrence and reformation, is an important facet of a modern civilized society. Crime control and prevention is again very important from the perspective of punishment. By incarceration of the offender, he or she is prevented from indulging in further criminal acts or omissions. Thus, punishment helps in controlling crime. Serious offenders are given life imprisonment with the purpose of protecting the society. And in the rarest of rare cases, the criminal may even be given the death sentence for the heinous crime committed by him or her. Now, moving on, punishment also serves a reformative purpose. Nowadays, the penal policy in most parts of the world leans in favor of reforming the criminal and devising suitable policies of incarceration, probation, parole, furlough, open prisons. These are aimed to reform the criminal and integrate him in the society. Furthermore, punishment also serves the purpose of restorative justice. The first and most important principle of the restorative perspective is that justice requires that we work to heal victims, offenders and communities that have been injured by crime or other harmful behavior. Moving further, the sentencing policy has to rely on the aggravating and the mitigating circumstances before awarding the punishment. Dear viewers, even though different kinds of punishments are prescribed under the Indian Penal Code 1860, ranging from death penalty to only fine, the courts, while awarding suitable punishment, takes note of several mitigating and aggravating factors and circumstances. It is noteworthy that in the Indian Penal Code 1860, for most of the offences, a maximum punishment has been prescribed. The courts have a lot of discretion in awarding the actual sentence to the convict. Sentencing policy takes note of the fact whether the offender is a first-time offender or a repeat offender, a habitual offender, a youthful offender, or a female offender. Punishment is awarded keeping in mind the nature and gravity of the offence, the circumstances of the offender, mens rea or the mental intention in the criminal, whether the crime was committed in the right of private defence or was due to a sudden fight or an act of necessity. The mental state of the wrongdoer is also taken note of, and then the victim of the offence, harm suffered to him or her. Moving on, the court also looks into the fact whether the offender can be reformed or not. Here it is pertinent to make a reference to the Law Commission of India 47th report, in which it was said that a proper sentence is composite of many factors: the nature of the offence, the mitigating and the aggravating circumstances, the prior criminal record, if any, of the offender, the age of the offender, the professional social record of the offender, the background of the offender with reference to his education, home life, the mental conditions of the offender, the prospective rehabilitation of the offender, the possibility of treatment or training of the offender, the sentence by serving as a deterrent in the community for recurrence of the particular offence. Justice Malimat had rightly observed with regards to the sentencing policy, punishment must be severe enough to act as a deterrent, but not too severe to be brutal. Similarly, punishment should be moderate enough to be human, but cannot be too moderate to be ineffective. However, when we look at the current sentencing policy, we realize that a lot of discretion is awarded to a judge in awarding the punishment. In this regard, it is important to highlight the observations made by the Committee on Reforms of the Criminal Justice System, whereby it was felt that the Indian Penal Code 1860 prescribes offences and punishments for the same. For many offences, only the maximum punishment is prescribed, and for some offences, the minimum is prescribed. The judge has wide discretion in awarding the sentence within the statutory limits. Therefore, each judge exercises discretion according to his own judgment. Therefore, there is no uniformity. Some judges are lenient and some judges are harsh. Now coming to the modern era, certain constraints are universally practiced in the sentencing policy in the light of the Universal Declaration of Human Rights, the International Covenant on Civil and Political Rights, and the Convention Against Torture. Punishment should not be so severe or torturous as to be inhuman or cruel. Secondly, it should not be imposed in a manner that results into violation of the offender's protective rights. That is, punishment should not only be in accordance with the procedure established by law, but also confirm due process by law. Thirdly, the rule of proportionality should be the guiding principle of the sentencing policy. That is, graver the offence, more severe should be the punishment. Fourthly, where there is a doubt as to the choice between two punishments, the less severe should be imposed as a general rule. Viewers, now we shall focus on the sentencing policy and procedures, and it is felt that still there is a long way to go and a very difficult way to go on account of various impediments which are in the way of speedy justice. In serious offences, delay in awarding of the punishment defeats the very purpose of deterrence and retribution. Many a times, the wrongdoer himself causes delay to prevent the infliction of punishment. Interestingly, the penal policy may not be effective for specific groups. It has been noticed that the penal policy may lose its efficacy for specific group of offenders who consider crime as an occupation. They are not afraid of punishment and may commit crimes again and again after being released from the prison. Dear viewers, it is seen that in India, for most of the criminal acts, the Indian Penal Code has prescribed the maximum amount of punishment, and it is left to the discretion of the judge to determine the actual quantum of the same. A huge difference is seen in this regard. Now coming to a very controversial aspect of capital punishment or death sentence, in the matter of awarding capital punishment in India, the rarest of rare case principle is applied. Now, the rarest of rare principle for invocation of death penalty has been criticized as it involves a lot of judicial discretion. Furthermore, once the death sentence is executed, it becomes irrevocable. In the end, I would like to say that there is no denying the fact that punishment is a necessity. Every state has to devise a suitable penal policy to protect the life, limb and property of its people. However, the penal policy must strive to balance the two conflicting interests. First, the interest of the state, society and the victim by awarding suitable punishment to the wrongdoer, and secondly, in ensuring that the punishment is in proportion to the crime and is not excessive or inhumane. In the end, I would like to conclude by a famous saying by Kautilya. Kautilya said that if punishment is too severe, it will alarm a man. If it is too mild, it will frustrate him. But if properly determined, makes man conform to dharma or righteous conduct. Thank you.